In this video, we will be looking at building encroachment. So we're moving on to situations where you already have a building constructed and that building has a permanent trespass, a continuous sort of permanent trespass, and that's what we refer to as encroachment. So any part of the building can extend into someone else's land without authority, and that's where an issue arises. Why does that happen? Well, usually a building encroachment is a result of an error, and the error is usually due to mistakes in surveying. So when they first surveyed the building, the coordinates, it was a mistake that took place. But also you can find that error taking place when buildings are constructed very close to the boundaries, and also old buildings where the surveying wasn't that great. Now, parts of the building that are usually impacted, often you see it with balconies that extend to someone else's land, and also boundary walls, uh, external walls, and footings. So remember, we talked about subsoil and trespass in subsoil. Footings as well, if they extend to someone else's property, that will be considered as a building encroachment. Now, certain terminology that you guys have to be aware of. A person who encroaches onto someone else's land is referred to as the encroaching owner, and a person that's impacted by the encroachment, that's referred to as the adjacent owner. In the common law, how is encroachment dealt with? Most cases, the courts would issue an order for an injunction. An injunction is where they ask the defendant to demolish part of the building that's encroaching onto someone else's land. However, remember, the law has to be reasonable. So if it's unreasonable to ask for such an order, so in cases where the loss of the defendant outweighs the loss of the owner of the adjacent land, then the court might order that damages be awarded for the adjacent landowner. And in this case, the damages would compensate the owner of the adjacent land. So some elements the courts would consider, or some questions, if you like, that the courts would consider when they decide to award damages instead of an order for an injunction due to an encroachment of a building, is whether the injury to the plaintiff's legal rights are small. So if they're small, then they order damages be awarded. Would it be oppressive to ask the defendant to demolish? And if the answer is yes, then damages are very likely to be awarded. And also, can the encroachment be estimated via money? So can that estimate be made? It's essential that you can calculate that in order to award the damages. And finally, can the encroachment be compensated via money? So would that compensation through money be enough, sufficient to compensate, the person that has this building encroaching onto their land? Now, New South Wales has a set of legislation, and it's all embodied within the Encroachments of Buildings Act. So, New South Wales legislation, it handles issues with regards to encroachments of buildings. Now, it gives the options for both the adjacent owner and the encroaching owner to apply to the court for relief whenever there is an encroachment. So both the adjacent owner can utilize certain aspects of the act as well as the encroaching owner. How does that uh, come into play? Well, adjacent owners are often compensated via damages. So there's awards, like the court would award damages to adjacent owners, and that would be in the form of a payment that the other party has to make. For the encroaching owner, some of the situations where the act would come into play is where it would award the encroaching owner a lease of the subject area. So they grant them a lease of the subject area so that they are no longer considered as encroaching. or they can grant them an easement or a transfer of the actual part of the land onto which they encroach. So it really depends on the case and the situation. But these are all aspects that are prescribed in the Encroachments of Buildings Act.